Good evening, everyone. Am I audible?
Yes, sir.
Great.
Yes, sir.
So we'll start with today's session. In last session, I had given you a legal snapshot of how criminal machinery uh, is triggered and what are the different stages that we should be aware of uh, with their specific names to understand the full journey, the full legal journey that is taken from a complaint to of the court. So I'll briefly recap what I have said. What I have said is that we have three laws dealing with criminal law. One is First is the law which can be called as substantive code. The name of that is BNS, that defines what the offenses are, what the punishment for the offenses are. The second code is called BNSS, Bharatiya Nyaya Suraksha Samhita, which deals with the powers that are given to the investigative agency to investigate a crime. The investigation that happens is a pre-trial thing. So before it goes to the trial, before a matter is committed, the powers of the investigative agency as well as the safeguards given to the accused are given in the code. The importance of a code or a law is that if you think that even if powers are given, the reason powers are given and written down is because it limits the power. When you write down that this is what the law allows you to do, then the interpretation can't be then you can't travel beyond the law and do that thing. So the need for code is also a way of limiting the power that can be exercised, because there's some powers that have been given, and the purpose of it being written is there that every time anyone is collecting an evidence or conducting a search without a search and seizure warrant, or conducting a arrest without a warrant in case of a non-cognizable offense would mean that in that case they can be challenged. And then we have the third law, which is known as BSA, Bharatiya Sakshya Adhiniyam, or Indian Evidence Law. It deals with how the court will conduct the trial. What are the kind of evidence that would be allowed? How is it that testimony or witnesses have to be, witness testimony has to be taken? What can be asked in examination? What can be asked in cross examination? Just to recap what I have said is that I have said that the process first starts before the matter goes to the court or before the trial starts. The first process is that there is filing of a complaint through an FIR. If there is filing of a complaint through an FIR, then it would also lay down the offenses that are being made. And it is the job of the police to see that the complaint that is there, then what are the sections that can be invoked. Then if complaint has been made, then it has to be investigated. Investigation will come under BNSS, which means that the police might want to if the police on investigation wants to arrest a person of interest or suspect, then it would ask for an arrest warrant. If the police wants to conduct a search and seizure and collect evidence from the scene of crime or a related place, then also they would seek a search and seizure warrant. Then after that, the police then makes up their case. The police then files a charge sheet. A charge sheet is placed before the court. In order of conducting that investigation, the police might take custody of the accused. And if the accused, if it thinks that they have given all the necessary information and if they're still been kept in custody, then they will move for bail, saying that we are still an under trial and the process is that everyone is innocent until proven guilty. For the purpose of investigation, we should not be kept in police custody for so long or in judicial custody for so long that it turns into a punishment. Then we have the concept of bailable and non-bailable offenses. Bailable offenses are offenses which are non-serious offenses where bail is a matter of right. The offense under that provision in BNSS, it will say that if these are bailable offenses, this means that there will be conditionalities put on it. It can be that one, maybe that for some kind of, if someone is charged with an offense, that they have to deposit a security of 10,000 rupees. That is billable. So if the law itself says that deposit has to be made of 10,000 rupees, so the moment they pay 10,000 rupees, they can't be kept in custody. Then there are non-bailable offenses. Non-bailable offenses do not mean that bail will not be given. Bail can be given in every case. Non-bailable only means that it is not a question of right. It is a question of judicial discretion. So even for the most serious kind of offenses, a person can move for bail if they have been kept in custody while the investigation is going on. And then the court applies the principle to see if we give bail to this person, will this person interfere with the witness? Will the person then is in a dominant position to also uh, complicate or fudge the scene of crime? Or if the person has a standing that one can say that the person can be a flight risk, which means that the person, then the person will run away. Based on these criteria, the court can determine the bail conditions and give bail in all kinds of offenses. So, non-bailable seriously is a misnomer. It only means that bail is not a matter of right, that you meet the condition and bail is given. There is a judicial hearing for bail, and depending on that, the court will determine if bail has to be given or not. Once the police investigation is complete, they file a charge sheet. Then it comes, then we are talking about, from now onward, we are talking about uh, trial jurisprudence, that what happens when the matter is before the magistrate. Then in the first instance, the session judge will apply their mind and see if the charge sheet that has been filed, charge sheet will mean a complete picture of who are the people who are responsible, who is it that the state is trying to prosecute, and what are the offenses that they are charged of. Then, if the court thinks that there is prima facie on the face of it, the charge sheet is making sense, then the court will then frame charges. The court framing charges means that then the court declares someone to be an accused or a defendant, and the state will have to prove its charge. Now that all of it is guided by BSA or Bharatiya Sakshya Adhiniyam or Evidence Act. It's called Evidence Act because the way the trial has to be conducted has to be through pertinent rules. And these rules could be that who are the people which the prosecution or the defense is bringing as a witness. There are some kinds of witnesses that are, because of their relationship, are deemed as witnesses who can't be a witness. For instance, if there is attorney-client privilege, which means that an attorney can't be a witness in a case even if they have, even if they are not involved in that case, but earlier they were involved. Then there is husband-wife privilege. These are called privileged witnesses, that anything that has been said by a husband or a wife or vice versa cannot be taken, cannot be accepted as a witness, except in cases which have to do with divorce or domestic violence, because there the dispute is between husband and wife. Then there are other kinds of testimony which are not allowed. Anything that has been confessed to by the accused in police custody is inadmissible, because it is presumed that there must have been an element of coercion involved in that. So that can't be a testimony. That evidence is inadmissible. Then everyone brings their list of witnesses. Those witnesses will give their testimony. There can be examination from the other side. And after all of this, the court then decides on the presumption of reasonable doubt or beyond reasonable doubt, if the defense has committed that crime or not. If it thinks that the defense has committed that crime, then it will hold them guilty. And then under BNS only, they will look at what is the maximum sentence that can be given, what is the minimum sentence that can be given, and then they'll try to situate the facts of that case in that provision and then determine what is the sentence that they think is feasible. So this is the complete journey of how a case is made and decided by a court. Any doubts till now? If you have any questions, then I'd be happy to take it uh, on this part. Yes.
Sir, I have a question actually about what we discussed in the previous recorded session
Hmm.
about general exceptions.
Yes.
So this is a slightly absurd hypothetical, but I wanted to know if it comes under a general exception. So suppose a woman is having food at some restaurant and there is a man who is sitting at a table nearby, and this man overhears a group of people discussing that they plan to kidnap this woman and hold her ransom and demand money from her family.
Hmm.
Now, hearing this man, if he decides to deter this action by kidnapping her, as in by forcibly taking her away from that place, is
Hmm.
is that come under something that is done in good faith, or is that punishable?
Okay. This is an interesting hypothesis. So first of all, there is no cut and dry answer in law. Law is always any legal provision has to be applied contextually. And I'm prefacing it because it can be argued both ways. But if you ask for my opinion that how is it that I look at it, then how I would look at it that the defense will not apply. Let me tell you why. That the person thinks that this woman will be abducted, right? And they will hold this woman to ransom.
Yes.
And what is the kind of force that this person has applied in order to avert that situation? The person has abducted that woman.
Or say
Let me first
coerced.
explain
He
it
has
to you.
forcibly taken her away from that
Yeah,
place.
forcibly
Yeah.
taking her away is abduction.
Yeah.
So if you look at the section that I have said, that if a person is not able to take the person's consent and acts in good faith to save the life of the person. Now, one will say that abduction on its own, that is why I've said it depends on the lawyer that you have. If they claim that the defense will not apply because the woman's life was not in danger, obviously what the person overheard is a hearsay. It can be a figment of their imagination. So the point is this, that if in order to avoid abduction, the person also abducting her, exception can only be allowed if you have if without having that intention, you have in order to avert a bigger danger, which can be threat to life, that the person has acted in a particular manner. It's like saying that it's like saying this, that I think that there's some people who are sitting and they might commit the theft on my on commit the theft on my friend's property, that they are planning to take the person's laptop dishonestly, and what I end up doing is that I end up taking the person's laptop with me without informing that person out of that person's custody. Then one will say that you have also acted in a similar manner. The other way of also saying is if the woman's life is in danger and he overhears this and is able to give evidence to that effect to satisfy the court that look, I have recorded this conversation. They are planning to kill her. And at that moment, I thought because of some pretense also, I should extract this woman from that situation. And I lied to this person and took her in my custody without harming her with an intent of saving life, then maybe this can be a.
Okay. So, sir, what you're saying is, unless it can be proved that he actually heard this conversation, unless there's like a recording of this conversation, he will be
I'm just
held
giving a
liable
hypothetical.
for
What I am
kidnapping.
saying is this, that if you one has to apply a defense and act in good faith without consent, then one has to show that the action that they have taken, it pales in comparison to the danger that the person was facing. If the danger that the person was facing was abduction and I committed the same thing, then where is the defense? That is why I said that if the woman's life was in
Okay.
danger and he can produce, obviously, it can't be a figment of his imagination. He has to show proof for that. If he's claiming that defense, then one can say that in order to save her life, he at that moment had to abduct her or use some force to extract her from that situation. Because the degree action is a crime of a lesser degree than threat to someone's life or murder. That is my point. Is it clear?
Okay, got it.
Yeah.
Yes.
Any other question?
Sir, I had a doubt.
Yeah.
Sir, this is a hypothetical. What if there's an accused and this accused is on trial and his or her doctor provides, as a witness, provides a testimony that they were on pills. Is that evidence admissible or inadmissible?
No, that might be admissible. So let me tell you that first of all, if a doctor is coming, the doctor also has to take an oath that the doctor is not partisan, and which would mean that if the doctor's testimony is not credible, so they might ask another doctor to come and look at the situation of the woman and see if she was on pills or not, or if she has been a patient. But are you asking it for a particular defense of unsoundness of mind?
Yes, sir.
Okay. Then if you look at unsoundness of mind in the video that I discussed, what did I say? That the wrong that was committed should be such where a person at the time of the commission of that offense must have been incapable of knowing the consequences of the act. So even if a person is schizophrenic or if a person has bouts of delusion and is taking pills, it is upon the person to show that at the moment when the act was done, that the person was incapable of knowing the ramifications or consequences of his action. So if I bring your example, and it can open both ways. For instance, if a person is under medication, say depressive medication or antidepressive medication, but if the person is not able to show that the antidepressive medication is something that has taken a toll on that person for 24 hours whenever the person is awake, then the defense will fail. Because unsoundness of mind means not that there is a general unsoundness of mind. It means that you have to show that at the moment that, so if the person takes medications and they take medication to improve, and if the person is taking medications and generally is not suffering from some kind of very extreme delusion, then it would not be a defense, because the defense is the person when the act was committed or when the act was omitted which led to an offense being created. At that moment one has to show that the person was suffering from unsoundness of mind. So if a person has occasional schizophrenia where they imagine things, but if it can be shown that the person was sitting in office and doing their work at that moment when an altercation happened, then they will say that even if the person is generally a schizophrenic patient, at that moment the person was not incapable of knowing the consequences. Is the same thing. The logic is the same. Involuntary intoxication is a defense, which means what? If someone has been made intoxicated without their knowledge and some wrong happened there, then at that moment, because they were suffering, they were incapable of knowing the consequences, therefore the defense is accepted. So a general prescription of saying that the person was under medication will have no effect unless one is able to show
Yeah, so
at
what
that
is
moment, or if a person is permanently committed to a psychiatric ward and the person breaks through and in that the person commits something, then one can make that argument that the person was committed. to this kind of place, institutional place. And therefore, we must presume that the person does not know what the person was doing.
So what if it's the person's personal doctor to whom the person has confidence and in confidence confess that he was taking pills? Is that admissible?
So the thing is that I am saying that certain kind of things are inadmissible only if the person raises the plea that I have a doctor. But the doctor should just understand this thing. If a witness list is given, I am not saying that a doctor can't divulge. Obviously, a doctor can divulge, but what I'm trying to say is that if a doctor knows of a person's condition and that the person has extreme temper issues and that person is a defendant and the defendant does not want the doctor to come, then they can raise this claim that this person is my doctor, that one can call any other doctor and examine me, but this doctor should not be called because things that I have said to this doctor is in confidence. But the other thing is, if the person himself wants the doctor to come and be a witness, then what problem will the court have in making it admissible? It is inadmissible only, no. If the person says that, there will be, always understand what is the principle. The principle is it would be a breach of confidentiality if someone comes and be a witness against a person, if that person has shared something with them in confidence. But if the patient himself wants that my doctor should come and testify, then where is the question of breach of confidentiality? I am wanting that confidentiality to be breached voluntarily so that I can be saved.
Okay, sir. Thank you.
Thank you. Any other question? So let me now generally go to offenses, which is under BNS, Bharatiya Nyaya Sanhita, and tell you the basics of how the court frames the question about what is a criminal wrong. Always remember that there are two terms that will be used with respect to crime, and both have to be satisfied. One is mens rea, another is actus reus. Mens rea means guilty mind. Actus reus means wrong act. And that is why it is very important in criminal law to understand what is the intention behind a crime. If you only show this thing, that this act has been committed and that is on camera, then that is not enough, because one can then bring out a defense and say that I was acting in self-defense because the person had attacked me before. Or a person can say that I was forced to do these things because they had abducted my family. That is why the criminal wrong is based on also showing what is the intent of doing that. And any section that you read which defines offenses, which therefore use this word, either intention to kill or knowledge to kill or negligence or without due care or dishonestly or fraudulently. What does it show? It shows this is where the lawyer comes. They show that just because act has been committed does not mean that the person intended to do it or had knowledge of doing it or they did it with in a dishonest way. Let me explain it to you through an example, then it will make sense. And I want all of you to tell me that if a person is caught in camera that the person has stabbed another person and only this bit is there, what do you think? Has the person committed an offense?
We can't say for sure without proper context.
Without context. So I am saying that the action has happened, is caught in camera. It shows that a person has stabbed another person. Why can't you say it without more context? The person died, the person
supposing
stabbed.
Okay, so supposing in this
Why
camera
why
was
can't we say
recording,
that the person committed murder?
because we can definitely say that the person committed murder. The person did commit murder,
No, the person
but
did not commit murder.
we
Hear me out. Murder is a specific kind of offense where death is committed. What you can say is that death is committed. Whether it is murder or culpable homicide or gross negligence or grievous hurt is a specific kind of offense. Death is not synonymous with murder in legal terminology.
oh, okay, I didn't know that.
Yeah.
So then the supposing A stabs B, the death of B has occurred, but we cannot say that A has murdered B.
So you can't say on that basis that the person has to be punished. Because all
We
you know is
can't say
what?
in this
That
context.
something has happened. This is a fact.
Yes.
That A stabbed B, B died.
Yes.
Chaitanya
Yeah.
has a point, yes.
So that's basically the same point, that we've just observed that one person has stabbed another person and the death has happened to that person. We don't know whether what was the condition the two people were in before.
Yeah, so what is
Which
the
led them
term?
to
If
that.
I've given you two terms, actus reus and mens rea, what do you have?
I feel like actus reus, because we don't know the
Yes,
intention
so
of the
that is what I am telling. That in criminal law, one has to show mens rea and actus reus. If I just show you that someone stabbed someone, that you have the footage of that action. But now here, look at it. And all of you are right here. That is why mens rea is there. Death is murder only if the person intended to kill that person and kill that person. Intended to kill would mean that the person acted with knowledge that if they do this and there's some enmity. But look at the situation. Suppose what is not captured in the footage is that the person had put a gun to the person. The person that the person who died had put a gun to the head of another person, and in self defense, the person had a sharp weapon and they stabbed that person. So here the intention becomes important, no? And this is what comes out in the trial. They will have to show that there was this kind of thing and there are other witnesses, and witnesses will testify that the other person threatened him first and threatened him with a gun. And in order to save that himself, the person did not think much, and whatever he had, he stabbed the person. So this will come under self-defense. Now, suppose it comes to the mind that the person who stabbed the person is a person who suffers from unsoundness of mind, that the person is a person who is incapable of knowing the consequences of the act, and the person is committed to a psychiatric institution and has run away from that. Or if it is shown that the person is a mad person, then even if the person kills that person, there would be no consequences, because they will say that the person was incapable of knowing the consequences. The third thing would be that suppose there was no enmity between the person, and what happened was that suddenly a fight broke out between two people. In the heat of the moment, the other person was also hitting this person and this person stabbed him. Then even if death is there, they will say that there was no intention to kill this person, but the person had knowledge that the kind of force that they have used in ordinary course of the situation will lead to his death. So it is considered a culpable homicide not amounting to murder. Culpable homicide not amounting to murder means that there will be lesser punishment for maybe life imprisonment. But if you commit murder, then the maximum punishment can also be death. Then think about it, that if a person acted in a reckless manner, what could be reckless manner? That the person did not know the other person, and the person got this knife, and in a public space the person was playing with this knife or was wielding the sword in a public place. So this is stupid behavior, but here it is death due to gross and negligent action. And look at it, just as the mens rea changes from intention to knowledge to gross and negligent action to unsoundness of mind to self-defense, the punishment also shifts. In murder, it would be death. In culpable homicide, it would be life imprisonment. In death due to criminal negligence, it would be 10 years. In self-defense, it would be absolute immunity. In unsoundness of mind, it would be absolute immunity. So saying that the person has done this is not enough. What is the motive? What is the intention? What is knowledge? How do you categorize this? And there is a certain kind of hierarchy even within those mens rea. Some mens rea are something where they think that the person, if the person had a previous enmity with that person, the person engaged in that kind of planning, bought a knife, asked for 10 people about where I'll find that person, goes to that person and in cold blood kills that person, that is murder. A fight breaks out between people and they don't know each other. In the heat of the moment, they are engaged in a fight and the person gets hold of a sharp object and kills that person. It is culpable homicide, not amounting to murder because of knowledge. If the person is wielding a sword and ends up killing a person, ends up taking a swing that kills a person, is extremely gross and negligent action. Because a person did not intend to kill, but acted in such a grossly negligent manner without due care that a person died. If one is wielding a sword in a public space, it should be foreseeable that someone might be killed, even if you did not intend it to be. So is it clear? Any
Yes,
question?
sir.
You can think of some situations and then. So point I'm trying to make here is that actus reus and mens rea. Because if it is just a fact, then you don't need a lawyer. It's like mathematics. 2 + 2 is 4. But the society and the state also tries to look at the context and determine that why is it that the person acted in this manner. Yeah. Any questions? So if you look at my video, I have made a video which explains the difference between culpable homicide not amounting to murder, and criminal negligence. Look at it to understand. I've given you a lot of specifications on that. Then I'll again tell you how you generally think of a thing or an offense and how it is seen in law can be different. Let me ask you these questions. I am interested in knowing if a person has committed theft or not. Suppose you go to your friend's place and without asking you take the person's laptop and you get it to your place. Have you committed theft? What is the answer? So one will say that this is not theft on the face of it, because theft requires the mens rea of dishonest intention. If I am taking someone to be a friend and I go and take the person's laptop and the person is not there and I forgot to tell him, then it would be said that I didn't have the dishonest intention of moving the person's property and appropriating it. But suppose the same thing is done by a stranger. I don't know a person, the person comes to my room, takes my laptop and goes away. Then it would be presumed that one has a dishonest intention. I'll ask you another example. Suppose you go to your friend's place and the friend has a dog, pet dog. And while you are walking from his house towards your house, you start giving food to the dog. And the dog in that moment keeps trailing you till you come to your house because you were throwing food to that dog, and the dog is suppose your friend's property, and your friend says that you have that you have taken away the person's dog, or you have committed theft, then what is your response?
So that won't be labeled as theft because dogs have the tendency to follow wherever food takes them. And if the person was their friend, so the person must have visited their house and something with a lot of
Okay, so you are
capacity.
telling me that there is no dishonest intention. Now let me flip this thing. The same thing happens that a salesman comes to my house. I have a dog. I have no personal relationship with the salesman. The salesman asks me about the dog, and then without touching the dog, and I am sitting in my room, the salesman starts throwing food to that dog, and the dog keeps trailing that salesman.
Right.
And the dog then trails the salesman to a distant location, which is his house. Has the salesman committed theft?
Yes, sir. I believe he has committed theft because no, wait. If the salesman was in the capacity to
The
know,
salesman has not touched the dog.
yes, sir, but if we know that if there's somewhere to prove that the salesman knew that the dog would follow the food, then he would have committed theft. If he didn't know the dog would follow him just in the pretense of giving food, then that is not theft.
Okay. So if that is what correct. So if the salesman thought that without touching the dog, there's a possibility that a dog will follow me if I give something that the dog is interested in, and the dog moved out, the dog moved out of the place of the master and start trailing the dog, where one can if one can show that salesman had no business giving food to the dog and keep giving it. So in this situation, first of all, the thing that should also interest you is that in law, and this is a sad thing, even other living things can be seen as property. Generally property we see as inanimate, no,
Yes, sir.
but dog is a property. And this means that even without touching, if someone is moving the dog out of the possession of the master and doing it with dishonest intention,
Yes, sir.
then that is theft.
Yes.
Tell me this: if a person is walking on the road and it's a deserted road, and a person finds a wallet with a lot of hefty notes sticking out of it,
All
and
right.
there is no address on that wallet
Hmm.
or identity card, and the person uses that money on himself or herself because it's a deserted road, then has the person committed theft?
Sir, there were no dishonest intentions in order to hurt someone else. There was no identity given of the person that the wallet belonged to one person, and therefore, if it was kept free on the road, he had two choices: to either take it to the police station so it could be tracked, or use it on himself. And it also depends on what kind of a person he or she is. If
No, what is the response?
I'm sorry.
I am saying that will this come under the definition of theft, yes or no, and why? It's not a contextual inquiry. Facts are given.
Sir, yes, it will be theft.
No, it will not be theft. It will not be theft because the first thing that if you look at my video, I have said that you are taking something which belongs to someone out of their possession.
Sir, then
Think of all this is the definition of the offense, that moving a property out of the possession of a person.
all right.
So did this person go to someone's house
No,
and took the wallet?
no.
It was lying there.
All
So
right.
he did not take it out of the possession of anyone.
All
He
right.
had also no, through reasonable means, he did not know who it belonged to.
Yes, sir.
So here the requirement, that is why in law one has to look at each word. Dishonest intention of removing something out of a person's possession,
All right.
which is movable, is theft.
All right.
Maybe the person has committed some other wrong.
Okay.
It can be if the person was a public servant, then it would be said that there is a criminal breach of trust or criminal misappropriation, but this is not theft.
All right, sir.
Now tell me this: can if there is a tree in my backyard, can the tree be can tree can the tree be stolen from my yard?
No, sir.
So there also tree can be stolen, but it has
I
to
mean,
be that it has to be severed from the ground.
yes,
Anything that is rooted in the ground,
yes, sir.
one can't say that there is theft, even if it is of fruits or other things. So if someone cuts my tree, which means that the log is severed and takes it out of my possession, it is theft.
Yes, sir.
So I have given you 6 or 7 examples if you look at the video. These are ways of also thinking, and the important thing is the same thing that I said with respect to discrimination. How a lawyer looks at what is discrimination and how the world looks at what is discrimination in a broader sense is different.
Yes, sir.
So law gives you that thing that it has to be exact. So what you generally call as theft is not theft. What
Yeah.
you generally call as murder is not murder, is death.
Okay.
And one has to show actus rea and mens rea. Okay, I'll
Okay.
stop here if there are any questions. Okay. Now let me speak a bit about general defenses. So in criminal law, there are such defenses, which means that even if an action has been committed, which is considered to be wrong, then also the defendant can invoke certain situations to say that this falls under defense. If it is falls under defense, then the person can get complete immunity, which means can be acquitted or can get a lower sentence. Let me speak first about what are absolute defense. So now tell me this: if there is a child who is 5 years of age and there is something that is kept on the table which is poison, and the child comes and puts that poison in tea, and the person who drinks the tea dies as a result of it, how do you look at the action of the child? Yes, Archie, go ahead.
Sir, as the child is unknown of all these things that the material is poisonous and unintentionally he added the poison to the tea. So the child is not guilty of.
You are correct. And you are also touching upon. So what are we trying to see? There are certain things which are general defenses because even if the person has done it, the person did not have the requisite mens rea or guilty mind. In this case, the court will say that the person is incapable, because the person is 4 or 5 years, incapable of knowing the nature consequences of the act. So what has been done is condemnable, is wrong, but the child cannot be punished for it.
Yes, sir.
Now let me add another layer to it. Now, for some people who would want to be lawyers, in their mind some situation must be going on. Then it can be a very good excuse for someone to hire a child to do something, because there will be no liability. For instance, if a person puts, or if a person tells the child that this is a sweetening agent and you should go and put it on the person's tea, then what do you think would be the liability on the person who instigated the child?
Exploitation?
No, under criminal law, exploitation is a general thing where there is a dominant relationship. So this is all the concept is known as abetment.
Abetment to crime.
Abetment to crime. And in these cases, the abetment. So this is a situation where the person who committed the crime will be acquitted, but the person who had knowledge and abetted and ask that person or ask that child to pour that poison will be punished, even if the person who did that act will not be punished. And if the person died, then the person who instigated or misguided the child can be held for murder. This is just to address the situation if someone was thinking that there is a very good way of using someone who is involuntarily intoxicated or of unsoundness of mind or is a child, because even if this thing is done, there can be no liability, but there can be liability. There can be joint liability for all those people who have put that kind of, who have used that child who was incapable of knowing the consequences of that. So under criminal law, what it says is any action that is done by a child below 7 years of age is completely immune from prosecution, no matter what one does. Between 7 to 12, there is contextual inquiry, depending on what they have done, and there will be some evaluation if the child is able to know the consequences or not. If the child is, if it is thought that the child at that point of time has some idea, then the child might be punished with a lower sentence, of course. Then the second thing that is an absolute defense is again in unsoundness of mind. If a person was incapable of knowing the consequences of the act when the person committed that wrong, and the person was incapable of knowing the consequences, then would mean that the person suffered from unsoundness of mind. So the person cannot have any guilty mindset or mens rea. Is the same thing if the person is unsound mind and the person thinks that the head on the body of a person is looking very funny and takes an axe and severs the head from the body, and if it is proven that this is the kind of delusion that the person is always suffering from, then the person will not be punished, because what you are trying to punish is that certain kind of mindset is not developed. For instance, why is it that killing each other or killing one civilian by another civilian is murder, but when a person is taking away another person's life because the person is a soldier and that is a state of war, then that is not crime, that is applauded for the reason because it has to do with your state of mind. In one case, the state of mind was to harm a person with whom one has no enmity. In the second case, it is the state which is telling the person that everyone who is fighting you from that side is enemy. And in order to save our polity, even if it comes to it, you have to kill. Similar is the thing with involuntary intoxication. The word involuntary is important. If a person is consuming alcohol on their own and commits something, if a person is drunk and is driving the car and runs over another person, they can't claim the defense of intoxication. It is only when a person has been coerced into drinking, so much so that one will say that the person was incapable of knowing the consequences. Let me give you an example. Suppose a person is prone to consuming alcohol in moderate quantity, and one day a person goes and orders something in a restaurant without knowing that there's some alcohol in it, and then in that the person ends up slapping that person. The person can't claim involuntary intoxication even if the person had little knowledge, because what the court will then see contextually is that the amount of alcohol that the person had in the system is something that the person drinks on a regular basis. So it will not interfere with the clarity of the person's mind. Now, self-defense is another defense. Self-defense says that if a person's life is in danger or property is in danger or is facing the threat of robbery or grievous hurt, then the person can take all reasonable actions to address that threat that is there to the person's body or property or to another person also. And it can even lead to, in certain situations, taking away the other person's life. So, for instance, if a person is threatening me with an iron rod and I think that I am in grave danger, and in that moment I happen to carry a pistol or a knife and I end up stabbing that person, they will say that this is self-defense and I should be acquitted. So here also I killed the person, but I killed it because I had a reason. I did not choose it. Otherwise, that person. Similarly, if I am sleeping in my house and there is a house trespass and some people are breaking into my property, and in that moment I take the gun and shoot those persons, then I am doing it to avert a robbery. But the important thing is, and let me ask you this, suppose a person threatens me with a knife and I show that person the gun. The person is about to attack me, I show that person a gun. The person gets scared, moves his or her back to me and starts to retreat. In that moment, I shoot that person. Do you think this is self-defense?
Sir, it can be argued both ways because it's about how the person feels at a flight. So when someone is in your house trying to rob something and they have a weapon, your flight or fright kicks in, and you're very paranoid at the moment that this person does not do any harm to me or my property. And if the person turns around, so the person who's actually holding the gun may think that the person is taking another weapon or something that they can use to hurt that person. So it can also be called self-defense.
It can be called, but it is not what you think or what I will think. It is what the court will reasonably think. I established the fact. The fact is that the person showed the person the gun. And I said that the person got scared, turned the back and started to retreat.
All right.
If there is retreat and if you have used force and the person is killed, then there is no self-defense. Which is what I am trying to say. Self-defense is something that is given to you to avert the danger. It can be argued both ways, but I am saying that if the court thinks that there is no flight rate, that the person was retreating, even if earlier the same person has put you in danger, then there is no self-defense. Second thing, the threat, the force that you are using in self-defense has to be proportionate. For instance, if someone is trespassing into my land in the middle of the day, trespassing means what? I have said that don't enter without permission. This is private property. A person suddenly tries to open the door and come through the main door only, is entering into my property. I have said that no one will enter my property. In that, if I end up shooting that person, then it would be a disproportionate use of force.
All right.
What the court will say is that there were other ways for you to address this situation. Why did you kill that person? Why did you beat that person? You could have pushed that person out if you have written that no one will be allowed. But if a person is entering with a sword into my property and I look at it, the person enters, I shoot that person. There they will say, I'll say that look at it. The person was entering with a sword. So in that, the reasonable response is to first kill what I consider to be a threat.
All right.
So then the other defenses like acting in good faith and consent. Consent is a good thing. That if someone has given their consent to a certain thing and the person then suffers an injury in that process, then one can say that you have consented. For instance, if one is doing bungee jumping and one is signing some form saying that I will be able to handle my heart rate and I would want to do this. And suppose if the person is doing bungee jumping and the rope does not break, but the person dies because of anxiety, then you will say that the person consented. that that the person had a sensitive kind of thing. But there also what the law claims is that if that generally one can't consent to their death. One will not say that I consented to death. So except causing death, consent is a defense. For instance, if we go to watch a cricket match in a stadium, then if I have bought that ticket, there is that implied risk that a ball might cross over the boundary and come and hit a spectator. If a spectator is hit by a ball, which in that stadium, then one can't claim that one has been hurt. One will say that you consented. These are inherent risks that are there if you're going to watch a match, that a ball might come and hit you, that one signed up for it. Similarly, if one is playing a game of kabaddi or wrestling, and some kind of rough tackling is there, if a person is hurt, then the person will not say that I am hurt and I am injured. If the game is being played within the rules, if the person is getting hurt, they will say that one consented when you entered that field. So in today's class, what we have looked at, I first told you again, recap, what are the different processes through which one can make sense of a legal case, how there are different stages during pre-trial. There is filing of FIR. There is a way in which investigation has to be done. There are conditions that have to be put if a person is arrested. Then when a trial happens, then not everything that we think is made admissible. There is a manner in which things are made admissible. There is a way in which examination, cross-examination happens. From there, we looked at the substantive code, which is what is the meaning of mens rea, why mens rea has to be factored in, what is the difference between murder and culpable homicide, and gross and negligent act. What is the difference between theft and other actions? What are general exceptions? So if you have any questions with regard to this, then please go ahead. Anushka Chatterjee has a question. Sir, I have a doubt. Is it ethical for a lawyer to attempt to make a witness look unreliable even when the lawyer knows the witness is telling the truth? No, I don't think. It's because one is not standing in a court in people's court. One is standing in a court of law. And in a court of law, there are ways in which one has to show it. We don't know what is the truth. One person's truth might be another person's fantasy. So if all of us have encapsulated rules and procedure that one has to adhere to, then a lawyer's duty is only to that rule of law. Because believe me, if everyone is following rule of law, no, then only we are safe in a democracy. Because tomorrow, if one thinks that a person has committed such a heinous crime that the person does not deserve a trial and there is mob violence, then the same force can be used on someone who is just giving an unpopular opinion, who is writing a book, who is challenging the dominant narrative. So one can't choose, because even our morality is very subjective. What we have in terms of unanimity are these processes. So even if injustice might be committed to a particular individual because of how procedural the processes and safeguards are, in the long run, the republic and the country is better served by tethering to that rule of law. Any more questions? Okay. So, Nitika, yes, Nitika.
Yes, what about this scenario? What if a child under the age of 7 unknowingly sees poison in the house, but unknowingly puts it in food and a person dies, will the person who kept it simply lying around the house liable because it is a reckless act?
Yes, that can, which is what I'm saying. That if you have seen, if you have even looked at, uh, if you have looked at trial-based movies or books, you will see that is not that only there is only one defendant. There can be different people who can be charged for their role. So if anyone placed poison in a place where their food items that are kept, and if even if the small boy has delivered it, then also the person who has done it either carelessly, or if the person has done it through some design, can be held liable. That is why we have what is known as joint liability or criminal conspiracy, or the concept of abatement. For instance, if three people are fighting, if two people are fighting and another person is and there's a fist fight going on, and another person who is standing there, the person uses the anger of two people who are fighting and handles a knife to that person, or hands over a knife to that person, and the person ends up killing the person, then the person who handed the knife has also abetted in murder, no, by passing that knife. So that person will also be held guilty. It's the same logic in what you said.
Okay, sir. Thank you.
Okay. Thank you.